Addressing dual agency and related issues in Arizona. Let's delve into the concept of dual agency and its application in Arizona. Arizona, like many other states, operates under the framework of brokerage agency, which encompasses three distinct types of agency relationships dictated by state legislation, regulatory rules, or constitutional provisions. The first type is brokerage agency, where agency emanates from the designated broker, DB, who serves as the responsible party overseeing the brokerage's operations and compliance with state regulations. In Arizona, the Arizona Department of Real Estate, ADRE, mandates that every company appoint a DB. When two licensees under the same DB engage in a transaction, with one as the listing agent and the other as the buyer's agent, it constitutes dual agency, aligning with regulatory requirements. The second type is office agency, where each office designates a DB-type individual responsible for the office's operations. While some states allow office agency, Arizona does not recognize this model. In states that do, two agents within the same office engaging in a transaction would be considered dual agents, but this is not applicable in Arizona. The third type is single agency, where agency relationships are solely based on the individual agent. In Arizona, engaging in dual agency occurs when a licensee sells their own listing. However, Arizona does not allow single agency as a standard practice. Dual agency becomes inevitable in scenarios where two licensees from the same brokerage engage in a cross-sale, treating both the seller and the buyer equally. This situation poses challenges for brokers who must ensure proper disclosure to clients before any contract is written, especially on the purchase contract. The process involves navigating hurdles to communicate the dual agency arrangement transparently to both parties involved in the transaction. Or the buyer might ask what that means to be represented by the listing agent as well, requiring the listing agent to explain how it will work. We ask, if the buyer accepts that, what's next? Have the buyer complete and sign the READ form, checking the box that you represent the seller only. Tell the buyer that as the seller's representative, and the fact that the buyer will not have representation, that you will view. Write the contract. Help the buyer with financing, the appraisal, inspections, etc. Work with the buyer, but you still represent and work for the seller. On the last page of the AAR residential contract, the licensee should complete both broker sections, broker on behalf of buyer and broker on behalf of seller. Of course, check with your broker, as your broker might have a different policy on this matter. On both sections, check the box that says Seller Exclusively, and again, when the buyer signs the contract, remind them that they do not have representation in this transaction. This can be a delicate balancing act when representing the seller, working for the seller, yet working with the buyer. Yes, you will do extra work, but you will want to do this to be sure your seller is protected. If the seller wants to avoid paying a co-broke commission, they are well within their rights to do so. However, in instances where the buyer insists on having representation by the listing agent would be compensated from the agreement in the ER. Actually, it is not up to the listing agent to share their agreed commission with the co-broke anymore. Where does the offer for a co-broke from a seller come from? The seller. The buyer would attach the seller compensation addendum with the offer, and the seller would accept or counter the amount asked for from the buyer's agent. There is no place on the ER anymore that states what the seller is offering to a buyer agent. When taking a listing, you could also put in the additional terms and conditions that if you find a buyer, you might discount your commission if you are agreeable to that. That would have to be talked about beforehand. If you did not agree to something like that, you could renegotiate the terms of the listing agreement and would have to write up a listing agreement addendum. Alternatively, the buyer may seek clarification on the implications of this decision, prompting the listing agent to elaborate on the operational details. Once the buyer acknowledges and accepts these terms, the next steps come into play. Direct the buyer to complete and sign the READ form, indicating that you solely represent the seller. Clarify that as the seller's representative, you will draft the contract, assist with financing, appraisals, inspections, etc. Collaborate with the buyer, albeit maintaining representation and allegiance to the seller. On the final page of the AAR residential contract, the licensee must fill out both broker sections, broker on behalf of buyer and broker on behalf of seller. It's important to consult with your broker as policies may vary. In both sections, select the Seller Exclusively box. When the buyer signs the contract, reiterate that they lack representation in this transaction. You may also have a broker who wants you to write Unrepresented Buyer in the name area in Section 9 of the contract, making sure that you have an read and an unrepresented buyer addendum signed. Balancing the role of representing and working for the seller while collaborating with the buyer requires finesse. Despite the additional workload, ensuring the seller's protection remains a priority. Certainly, limit your responses to what the parties dictate. For instance, if the buyer suggests, "Would the seller agree to fix the ceiling fan?" respond with, "If you desire that, inform me, and I will include it in the documentation." Here are some common queries that arise when collaborating with a buyer without representation. Do you draft the contract? Yes. However, it's important to note that the role is limited to transcribing the buyer's requests without providing input on pricing, terms, down payment, etc. Do you assist the buyer in finding a lender? Yes, but without delving into discussions about lender programs, favorable terms, pricing, etc. Do you aid in locating an inspector for the buyer? Yes. Remember, this can get you into a fix if the inspector you refer misses something ginormous. Give them a few inspection companies that you trust and have used in the past, and tell them to select one that fits their needs if they are not savvy enough to Google best inspectors, roofers, plumbers, pool companies, etc. Do you help the buyer meet their time obligations? Yes, but solely by presenting timelines without offering specific advice. So when the BINSAR is due, you would ask them if they have any repairs they would like to request. You would fill out the BINSAR per their instructions. Lender's LE and docs to title, you could call or email the lender directly. LSU, you could also contact the lender directly. Do you guide the buyer through the BINSAR process? Yes. Once again, only by transcribing their directives. For instance, if they inquire about whether the seller would agree to fix something, the response might be to suggest they ask the question without disclosing potential seller responses. Do you accompany the buyer to property-related activities like inspections, appraisals, walkthroughs, etc.? Yes, as it is a practical necessity for accessing the property, as they do not have an agent to open doors for them. If the inspector or appraiser has a CBS key, you would not have to be there. Do you inform the buyer about sending a cure notice in case of seller breaches? Yes. We previously discussed your fiduciary duty to your client, the seller, while emphasizing the obligation to be fair and honest to all other parties, including the unrepresented buyer. To fulfill this fairness obligation, you would provide assistance in the aforementioned scenarios. It's crucial to adhere to your broker's policy and procedure manual, which likely outlines your responsibilities to a buyer in this particular situation. What about just using a facilitator? Say you know two people, one wants to sell and one wants to buy the same. If you use AAR forms or are being compensated, you must be an agent of one or both. Arizona differs from other states in not permitting facilitators, a concept often debated and favored by commercial brokers and non-residential licensees. In commercial transactions without a formal offer of compensation, brokers commonly turn to third parties, typically attorneys, to draft contracts that include the agency representation of the brokers. Facilitation involves assisting parties in reaching a deal without officially representing either side. While this practice is allowed in several states, Arizona stands as an exception. State regulations mandate that if a licensee in Arizona is preparing documents or being compensated for such services, they are obligated to represent at least one party in the transaction. This obligation is rooted in Article 26 of the Arizona Constitution, enacted in 1962. Article 26 grants licensed real estate brokers and salesmen the right to draft various instruments related to property transactions for the parties involved, emphasizing the role as an agent for one of the parties. The interpretation of this constitutional provision has been subject to debate, but the consensus is that Arizona real estate licensees cannot act as facilitators due to the directive stating they must act as agents for the parties involved. In the 1990s, the Arizona Association of Realtors, AAR, introduced a revised residential purchase contract that allowed agents to choose whether they represented the buyer, the seller, both, or neither. However, the Arizona Attorney General intervened, citing a violation of Article 26, leading to the removal of the option to represent neither party. While other states permit facilitators or transaction coordinators, Arizona does not. The term transaction coordinators in Arizona refers to individuals handling files for licensed agents, not facilitators. Despite variations in other states, Arizona, under Article 26, mandates that anyone involved in a real estate transaction, regardless of the type or compensation, must represent at least one party. Arizona does not permit facilitators.